Okay, it's time, 2:30. So, okay, Representative Kennard, and your mic what? Would you open us in prayer?
Thank you. God, we thank you for this day. We just feel so grateful. We enter your gates with thanksgiving, your courts with praise. We thank you for this day and our opportunity to improve this state. Let your kingdom come. Let your will be done. And it's in your name we pray. Amen.
Amen. Thank you. Okay, first on the agenda is going to be House Bill 373. So I'm going to ask Vice Chair Kirby to act as chair and call Mark Butler up.
All right, table mic. All right. Mr. Chairman, you've got House Bill 373. You can present it.
Yes, sir, and working off LC 363810. And since this is an agency bill, I'm going to let Commissioner Mark Butler present the bill.
Thank you, Chairman and members of the committee. This is kind of our agency cleanup bill. Parts of this bill you guys, or a lot of this bill you guys actually voted on and passed last year. And somebody over in the Senate decided to amend it on day 40 at the last minute with some language that caused an issue for another agency onto our bill. And so they had to veto it. And there wasn't enough time left in the day to take the amendment off. And so we're back to get some of this passed again. I don't know if y'all remember, the biggest portion of this bill has to do with, and this is one of the craziest bills that I've ever had to deal with, and that's saying something for me to say that. But a few years ago, we were told in order to access the IRS's database that they were no longer going to recognize the GBI background check for our employees that were doing it. That from going henceforth, they wanted us to have a national background check conducted by the Department of Justice, FBI. So we said, fine, okay, no problem. So we contacted the FBI and told them what we were told by the IRS, that we had to use them for background checks, and they said, well, does your state law require it? Well, no. State's not requiring us. The feds are requiring us as well. In order for us to do this, then your state has to require you to do it. So, of all the nonsense I've ever heard, so now basically we have to have a bill that requires us to ask the Fed to do something that they ask us to do. That's about the best way I can explain that to you. So that's the big chunk of this. We also have some other provisions in this bill that change some very minor things about the start date and the end date having to do with ineligibility for unemployment, also for eligibility of unemployment. This is, I'll tell you the reason why we're doing this. We found out that we were the only state doing it the way we were doing it. And the reason why, and some people say, well, why does that matter? Well, this is why it matters. We've been in the process of trying to get a new unemployment system, computer system, software system. And one thing that we found out is when you're having one of those built, and you have to have it built, the cheapest way to go about that is to buy something that somebody else has already had done, or buy from a company that's already done it. And what we found out was during all this process is because some of our laws are different about start date, little things, it seems like they're little things, it actually causes hundreds of thousands of dollars of additional programming because we're different than somebody else. So see, somebody else has already paid to have a program one way. A lot of things we've had to change were done through rulemaking or different things like that. Those were easy, but we found these two things were actually in law and need to be changed by law. This is actually $1 million provision. That is no lie, $1 million. That's the difference it would take to reprogram for us as opposed to just copying and pasting from somebody else's. And so we wanted to get in there and get that done as we're continuing to try to get a new system put in place. save the state of Georgia and taxpayers $1 million just by changing a little bit of language and start date. And actually, it will also stop some confusion from claimants because it gives a definite date, and it's the same every single month. Whereas it could be on different days. It also takes a lot less for us to figure it because it'll be consistent. And generally, quite frankly, it's actually in the claimant's favor, because if they made a claim based on a Wednesday, it actually rolls it back to that Sunday, the prior Sunday, that kind of thing. So it's good. Also, we also found out in here there was another issue where for just one provision in the law, somehow some language got snuck in at some point, and it was made aware to us by a lot, and I mean a lot of small businesses across the state of Georgia had this complaint, where if someone was let go due to excessive absences, even though they had been warned many, many, many times, and it was documented, you could have done all the things right that you're supposed to do, and then you were let that person go for cause, we found out they could still get unemployment. And how they were able to do that was somehow it got put in the law that not only did you have to document to them that, yes, you have to show up for work, you can't be absent multiple times, but that you also had to put in writing, and just for this one case, if you get terminated for this cause, you may lose your unemployment benefits. All right, that's the only cause that language is in there for. Everything else, whether it's theft or whether it's not being able, not doing the job correctly, or fighting, or what, doesn't matter. You don't have to put in writing that specific language, and it's actually tripped up a lot of smaller companies throughout Georgia. Bigger companies that have large HR departments or have a bunch of attorneys on call. Actually, though, I did talk to I was talking to a labor attorney about this the other day, and they didn't even realize that was in there. And they go, "I've been telling my clients the wrong thing." He goes, "I didn't realize it was in there." And so through a lot of requests from a lot of small businesses, we want to make that the same for all causes, because right now that's the only one, and that's tripping up a lot of people. And the only reason why we noticed it is that some enterprising person found that in the law and used it in a case, and it got overturned. And then it caught some of our people at our office by surprise, and we went and looked and said, "Oh my gosh, when did that get put in there? We don't know." But it's just for that particular one cause.
Thank you, Commissioner. Right now, there's a couple of questions popped up, but we just want to point of clarifying this. What you said is our federal government has no common sense anymore?
Anymore? I'm like, that makes the assumption that there was some common sense to start with. I'm not so sure about that.
Is that 19? Is that you, Representative McLean?
Yes, Mr. Chairman. Thank you very much. Thank you, Commissioner, for coming too, and thank you, Mr. Chairman. I guess I have the only question I really do have is, so what kind of background checks are we doing now?
Well,
I mean,
now we have gotten permission until this law is passed to get the national background checks done. And last year they were going to cut us off, but we went to them hat in hand and explained to them what happened. And as they have to deal with Congress, they understand things can happen. And so they said, "We'll give you one more year. After that, then we will no longer have access to the IRS records, which we need to have." So they told us we have until this spring to get this fixed, or they're going to cut off, or they're not going to do background checks for us anymore. And so that means if we have people come on board, new people, they will not be able to get that background check, and they will not be able to have access to it, which hampers our ability to do our job.
Thank you, Mr. Chairman. One more, just a little follow-up on that too as well. So will you have to go back and redo all the background check on all the employees that you have, or?
No, those have already been done. We've been allowed temporary access for them to do this, but they told us going forward that we're going to have it put in state law. I know it doesn't make any sense. Trust me.
I was just reading lines, 54 through 60, and it was just saying that it was kind of like you could go back and just do a background check on somebody that you was already employed.
Okay, in the case where you've got somebody who's employed for us who hasn't been using that, because people apply for different jobs, then yes, they may have already had a background check done that we normally do for everybody that comes to work for us. But then if they get switched to a job where they're going to be doing the IRS back and having access to it, then yes, they would have to. Yes, in that case, absolutely they would.
Thank you, Mr. Chairman.
I don't see any other questions. 15 just popped up. Is that Sam?
Yes, sir.
Representative Park.
Thank you, Chairman. Thank you, Commissioner, for being here. So I apologize for being a little bit late as well, and so if I ask a question that's repetitive, do apologize. Let me see. On line 46 to 47. Well, before I get there, if you don't mind, let me take a step back. Are you permitting does this bill permit the Department of Labor to do a criminal background check on anybody who applies for a job, or is it specific towards any employees who would be handling sensitive information?
We do criminal background checks on every person we employ due to the fact of the sensitive nature of a lot of things that we handle. Now, that being said, if you wanted to know, can somebody come to work for the Georgia Department of Labor who has a criminal background or has had previous convictions? Yes, in certain jobs. Obviously not in very sensitive jobs, depending on the crime. Because we actually have had people come and apply that have had criminal backgrounds, and we will allow that in certain situations. But obviously, if you're dealing with sensitive information like social security numbers and you have a criminal history and identity theft, you're probably not going to get that job. No.
On lines 46 to 47, it says we're an arrest and charge for a crime if the charge is pending, unless the time for prosecuting such crime has expired. Could you explain what that provision means? Where does that essentially mean that if you have been charged with something, that information would be a part of that background, even if you haven't been convicted?
Well, typically that's going to be a recent type charge, and that will show up, so it's going to be a part of it. Just like we tell individuals that apply for us, make sure that you're very, very honest. It will not preclude you from getting a job here as long as you're honest on putting down anything that you know, if you've got current charges or if you have past convictions, just make sure you list them all. Because if you don't, and then it comes up on your background check, which that will show up, then that'll keep you from getting a job, because then there's an honesty issue. Now, obviously, if you have a pending charge, yes, you would want to know about that too, because what if they're applying for a job and they've been charged with something, and then you find out after the fact that you've hired them that they've been convicted of, and then obviously that's going to be a problem. I mean, that's something that you would probably read about in the newspaper, depending on what the charge is. This employee of Department of Labor was just convicted of X, Y, Z, and if we didn't have the background on that, then you wouldn't have known it was coming. And so, I mean, obviously, we take a look at everything on a case-by-case basis. Something that would keep you from getting a job that was a pending charge, or that could keep you getting a job, we're talking serious charges that could make that happen. I mean, that would be for obvious reasons.
Mr. Chairman, if I may, one last question. With the information you require, including these fingerprints, that information cannot be shared with anybody else.
Correct.
Okay. Except to any person or agent, I'm on line 92, except to any person or agency which otherwise has a legal right to inspect the employment file.
Right.
So could you provide any specific examples of who that could be?
Be part of your HR department.
Okay.
Yeah.
All right. Thank you.
I mean, I don't even look at the background checks.
All right. That takes care of your questions. Mr. Chairman, do you have any closing comments?
Thank you.
What would be the will of the committee? Got a motion by Representative McLean to pass, second by Representative Hill. All in favor say aye. Aye. Opposed? Motion passes. On the rules, Mr. Chairman.
is Representative Kirby, and we're gonna do 110, which we have had 2 hearings on, and I think you've made some changes that are gonna make everybody happy. So, Mr. Kirby.
Thank you, Mr. Chairman. Bringing to you today House Bill 110, and this is on LC 363870S. In our last meeting on this, and I think there was a very good suggestion, and we put that in there. If you'll look on line 33 through 36, this is the requirement that at least 2 of those payment options are made available to all employees. And that would preclude somebody from just saying this is the only way. Now, the company can still choose all 4 of them if they want, but the employees will always have a choice now with this. We also did talk a little bit about cost on money network cards. And I actually brought one. I don't know if y'all have ever seen one before or not. So I brought this one because it gets into some things. It's kind of an interesting thing. Obviously, somebody came up with it's just a little black Visa card. This is the money network. Little box here is all an employee fills out. It's got their name, the employee ID that we use for payroll purposes, and then there's a security number and for tax purposes, of course. It costs them nothing. It does require, the $400 a month, so it's no charge. If it's not $400 a month, it's a $5 charge. But when we looked at everything, and I knew some of these, I just couldn't remember all of them. It has things like a 1% if you want to expedite payment by check, where the bank would actually write a check for you and then expedite or overnight it to pay a bill for you. It's got a, it actually has provisions for international use. And when you're outside the United States, currency transfer or exchanges of the U.S. dollar for each transaction at 2%. Crossing a border fee, and I'm not even sure exactly what that is 0.8%, or 0.8%. So in saying all this stuff, there's also some of these cards, I understand you can actually do a cash advance for a charge. There's just too many charges. We'd end up with 3 or 4 or 5 or 6 pages of trying to make sure that these charges were not having anything to do with your payroll. Where very simply it says, if it's on your payroll, the card use, no fee. Monthly maintenance, $5, but if deposits total $400 have been made in 28 days prior to the account, the fee is waived, so no fee. Payroll deposits, no fee. Direct deposits of other funds, including tax refund, no fee. Load cash funds from somebody else, no fee. Load checks via mobile app, no fee. So, these are not costing employees anything to actually use. In some ways, I explained to somebody before, this is almost like a little square plastic bank. There's so many things you can do with them now in this electronic age we live in that they just make it very convenient, but it doesn't really cost you anything. But until you get into some of those, you start crossing the border doing currency exchanges and things like that, there could be some cost to it. So that's why we couldn't really put that in there. We couldn't figure out without going 2 or 3 pages of wording how you would say that. We did check the money network card at Walmart. It's actually called a Green Dot Bank. I don't know what they got that name. Those cards actually cost $1 to buy them at Walmart. I don't know whether employers do that or employees. These are free. They're free to the company. They're free for us to give out to our employees. So I know there's options out there that are free, but we know Walmart's so readily available. We did check on that one as well. Other than that, that's all the bill really does. I think we've talked about enough. I think it's pretty simple, but I'll certainly answer any questions you might have.
Okay, well, I thank you for being willing to slow this down and answer the concerns that folks have. So, Representative McLean.
Thank you, Mr. Chairman. Representative Kirby, I've always had problems with this bill, and I don't think none's going to change. But I guess what I'm most concerned about now is not what you put in, but what you took out in lines 45 through 53. That's You know, it's that concerns me more than anything else. I mean, more so like, you know, to be able to opt out. Don't get me wrong. I mean, if I try something and if I don't like it, I do think that, you know, I'm just talking, I should be able to opt out or go back. I don't know. I mean, but I don't know why you took it out, but there had to have been a reason for it to be taken out.
Well, if you've got the choices to make now, you don't have to, a company can't say this is how we're gonna do it, but unless you opt out of it. You know, now you have at least two choices, if not more, depending on your employer. So there's nothing really to opt out of a required one thing to do.
Okay, so you're saying if I start taking the card, I mean, I just want to make sure, Mr. Chairman, I want to make sure I understand this clearly. If I start taking the card and all of a sudden I want to opt out, I can't opt out.
Yes, you can go to the employer and change to whatever else they offer anytime. We have people, you know, I'm
I'm just-
surprised. I've had people sign up for the card, and I'll tell you straight up. He told me, he said, I want it on the card till I open up a second account, because then he wanted a second account his spouse did not know about for a little bit of money to go in. And as soon as he opened the account, he came to us and changed his paperwork, said, I want to go to direct deposit into these two accounts, and I want this amount go every week in here, and the rest of it go into the one my wife gets. So
I mean,
there's a lot of reasons employees do it. You've dealt with people enough. So,
I was just only concerned that you took it out and
well, if you read the original wording of the bill, or the law, it really almost sounds as if a company could just say, this is how we're gonna pay you. And so then they had this in here and say, but if they were paying you this way and you didn't like it, here's how you opt out of it. Well, we're saying, no, we're gonna give you choices up front, so you don't have to worry about opting out. So I think it makes a lot more sense.
Chairman, just one more question, since the only thing that, you know, I just met with some millennials, and I told them about this bill, and they looked at it. They says, you know, I wouldn't do that because they could follow me with that chip, you know, in that card. They could see what I buy, what I do, and I'm just repeating. So I'm just letting you know, this is the feedback that I got. And so let me finish, because I don't, you know, you think it's funny, but I don't. And then one of them says, God, if I wanted to really buy a house, I guess I can take my card down there and buy me a house with the card, or either I could pay my rent with this card. I mean, they were just going on and on with things, you know, Representative Kirby, that just, you know, it just made me feel like, wow.
Absolutely. I have employees that make their rent payments and their mortgage payments with their cards every month. They can do that. They absolutely can, and then it makes it very simple for them. On us following you around, I'd ask them if they have a cell phone. That's a little bit easier to follow cell phones with the technology today where you are. And I don't understand the ghost mode and everything.
I think it was more so what they purchased, you know, more so whatever they used the card to do. But
that's, I think,
Thank
probably the
you,
nature of the
Mr.
beast we
Chairman.
live in. So.
Sam? Okay, Greg, Mr.
you.
Kennard.
Thank you, Mr. Chairman. Representative Kirby, as it sits now, the bill would require employers to offer at least two forms of payment. It would,
Yes.
every business in Georgia would be required.
Yes.
Okay, thank you.
Anybody else? We have a motion to pass. We have a second. All those in favor say aye.
Aye.
All those opposed? No. All right, we're gonna have to do a hand count. All those in favor say aye, or raise your hand. All those opposed? It's 4-5. That's correct. I think I'm only allowed to vote on a tie.
No, you're allowed to vote in any of your committee meetings.
What's that?
You can vote to create a tie or break a tie.
It-
It depends on the rules.
Okay. All those in favor, raise your hand. Okay. All those opposed, raise your hand. All right, it's a tie, so we're not going to move on it. Okay, thanks. Okay, next on the agenda is, you can stay right there. This is House Bill 474. All right, go ahead.
All right, thank you, Mr. Chairman. I bring to you today House Bill 474. And yes, you are reading right. You see Representative McLean and I both sponsoring the bill, and as far as we know, hell has not frozen over today. So, so, last year on, it was late day 40, there was a legislation introduced, the Senate, an amendment. And what it basically said was to the State Board of Workers' Comp is, we're not happy when you change the law or make law through the regular rulemaking process. And of course, that was a pretty big hammer that came up at the last minute. In talking to some of the people in Governor Deal's office, he did veto the total bill. It was disappointing to hear some of the things they thought was in there that I don't think was in there. It never was what was intended to be in there either. Then we had a hearing this summer, and we talked about it. We listened from stakeholders. But even in that meeting, again, we told them, but the purpose of the problem we have is when they go overboard and they make law, or they change the law that was passed by this body. And now we're here a third time. And we pared it down to basically two things. Because we love the advisory council. And they do a great job recommending the laws. And it made our workers' comp system one of the finest in the nation. But when the rulemaking goes along and the rulemaking comes out, and it's changed the law or it's made new law, we'd still have a problem. And I would have thought the advisory council would be with us on that, because they're the ones recommending it to begin with. And somebody said, well, they don't really do that. Well, we've got several things they can do. There's the Rule 240. About light duty and suitable employment. And nothing, and when we, matter of fact, in the code section, it basically says, if somebody gets hurt, and we don't want that in any place in Georgia, and they go to the doctor, and the doctor says, yeah, you got a muscle strain or whatever it is, you need 3 or 4 days with some light duty, and the employer says, well, we've got that, we'll help them, because we can pay them, because that first 3 or 4 days, they're not going to get any payment anyway. And the employee just simply says, well, I don't want to work. Well, what the law says is, then they're not entitled to indemnity. But the 240, the 248 process, now they want all this stuff filled out, all this, everything they could think of added to it, to where then the doctor sign. And it's about a 2-week process with some doctors, depending on what the kind of relationship and how busy they are and how they do their paperwork before you get anything. And that poor guy is sitting out of work now. It gets in between employees and what they need to, what we can do to help them. We've got 2000.2. Yeah, I do HR, and so I'm going to be a little more to the employer side, and Representative McLean's going to be a little more to the employee side. But look at 2000.2. It talks about medical case management. It allows a insurance company to hire a nurse to go get involved in the private business of this employee. Now, the fiduciary relationship between the employer and the employee exists because we're paying the bills, but a nurse case manager, if it's not a catastrophic injury, just a regular follow-up to get involved in what's going on with them, a muscle strain or sprain or whatever, never was intended in anything we passed that says, hey, we need to insert these case managers in this process. You know, I've kind of been very shocked to hear that the idea of having a 30-day public comment is bad. What's going on they don't want people to know about? And then the second thing is, right now, they're supposed to notify us. Now, after last year, Chairman Werkheiser finally did get a notice. Prior chairman we've checked with did not. We don't know where it's going, so we put that in there. You know, go to the Legislative Council and come to this committee. You know, so we get notice, so we know what's going on with these rules. And then if the rule is more than a rule and starts changing law, then we have a chance to act on it. Now, granted, we have that today. We can always come back the next year in the next session and pass a new law if their rule went overboard. But you know, we should put that in the rulemaking process. Pretty simple. We don't want them under the Administrative Procedures Act. That's not where it belongs. They're not a state agency per se. They're not in our budget, but they certainly, every employee and employer in Georgia is affected by workers' comp, and we've got a responsibility to them. And it's, you know, that's all it really does. It says we're going to have 30 days public comment, notify us, and make, as long as it's okay, we don't have, it just goes on. But if not, it gives us a little more mechanism to make sure we're not making new law through rules, we're not changing existing law through rules. I won't go through all this paperwork I got here in the interest of time. I know there's a sign up a few people have, and certainly answer a few questions if anybody has any.
Okay, Representative McLean. Representative McLean.
Thank you, Mr. Chairman, and also thank you, Representative McCurry, for bringing this bill. Well, first, thank you for letting me be a sign on this, because I do think it's a good legislation, it's good policy, it's good rule. And I don't have any questions, just had comment because I spent a lot of time reading it the day we talked about it, and I think it's good for both. As you just said, 30 days. I think that's great. Thank you.
Thank you. I'm watching.
Representative Park.
I am looking out for lightning strikes too when we're this close. So you know it's.
Mr. Chairman, did you
I
comment?
did. Representative Park.
Thank you, Mr. Chairman. Representative Kirby, so I just read through this bill, and there were a few things that I thought were interesting, which appear to stick out. So focusing on line 67, which says that no rule adopted after July 1st of this year will be adopted unless in exact compliance with subsections A through D. My understanding is that, you know, that does require that 30-day notice to be given, which seems reasonable. A2 on line 54, which requires that all interested persons are afforded a reasonable opportunity and that the board shall fully consider all of those. Those standards seem to be somewhat subjective and potentially subject to being contested based on the provision in line 69 saying that any rule could be contested on the grounds that this code section was not specifically followed. So would you mind just kind of clarifying some of those issues in terms of how this would operate?
Well, and I certainly understand your question and your point in the question, because that's one of the same things I had talking to the Legislative Council about. What does consider fully mean? I mean, you know, anytime we do a public comment, you know, there's going to be normally there's going to be opposing sides. So to fully consider it, if they're both opposing, you do nothing. So, you know, all this is really doing is making sure they're reading it, evaluating it, and giving them some time to set in. That's just the wording that I think they've used in other things. I think it is also very similar, if not right out of the same type of wording from the Administrative Procedures Act, so they kept that consistent. But if we got some different wording, we could certainly look at it.
Representative Kirby, if you don't mind, I've got two more questions for you. From lines 57 to 60, where it says the board shall choose an alternative that does not impose excessive regulatory costs. Again, it's that question of how are you measuring or how is that being determined? Because again, it seems based on how it's written, you could almost contest that on any grounds, unless there is some more objective method by which you could say what is excessive, relative to that specific area.
Well, again, if we've got some other wording, we'd be certainly
Yes, sir.
receptive to that. Especially in today's age, there are, Commissioner Butler mentioned different computer software that all of a sudden takes $1 million to write it because we have a different date as opposed to something you can buy off the shelf. All we're trying to get to is make sure, don't make it expensive, don't make it ridiculous, don't set a standard that makes no sense, especially for a small business. Large businesses may have an easier time doing it, but they're still in financial struggles to make money like everybody else. So that's all that's trying to do, and we're always receptive to new wording.
Yes, sir. So, Representative Kirby, and I thank you for answering all the questions. At the very end, Section E, line 78 to 80, just from my own understanding, is it the case that the legislator, our body, is capable of overturning any rule promulgated by the State Board of Compensation?
Well, we'd have to do it in legislative means. I mean, if they created a rule that we just totally thought was wrong right now, if we're still in session, or if they did it normally happens while we're out, we'd come back in the next January, introduce legislation to change the law that clearly states what we intended the first time, or never, sometimes some things get changed, sometimes they just get new stuff added, so.
So then would this then allow us to bypass that process by simply allowing us to object to any proposed rule?
It would allow us to stop the adoption at that time. Now, there certainly, of course, we would expect them to want to come and meet with us and explain it, certainly give them their chance to do it. It would just keep it from being the burdensome project of coming back the next year, especially if something's been out there for 6 months and then everybody's starting to have to do things to figure out what it is, and then we come back and change it again. I think it's just an undue hardship on both employees and employers you kind of try not to change the rules in the middle of the game.
Thank you, Representative.
Okay. Representative Hill.
Thank you, Mr. Chairman. And this is more like maybe a suggestion to consider. On line 76, instead of saying standing committee, how about considering House Labor and Industry Committee and Senate Insurance and Labor Committee?
I think that would be an appropriate change and certainly be well worth our time to make that change.
Thank you.
Representative Holly.
Thank you, Mr. Chairman. Thank you, Representative Kirby. I agree. Reading this it's been very good. I did have some concerns as expressed by my colleague, Representative Park, but I'm actually thinking maybe a suggestion. Maybe first get you to respond. Line 54, that reasonable standard. I know you've made it pretty specific to including line 40 and then line 73 about those particular amount of time to be set in terms of a reasonable person standard, just because it's discretionary. And, I probably would think that it may be best to probably include just what that might be, just to, kind of keep it clear. But other than that, I think it's well worded.
So on 54, it gives a person a reasonable opportunity, which is the 30 days. You mean consider fully needs to be, is it what you're suggesting?
Oh, no, got you. So it is supposed to be specified that it is 30 within that 30-day period, within that time period. Okay.
Because number one is that at least 30 days, so it's that notice of action or of an intended action of that time period.
Understood. Thank you for clarifying.
Okay, I don't see any other questions. We do have some folks signed up to speak. As Kirby started out, this has been a little contentious, and we've already had a long 2.5 hour hearing during the summer. So, if you would, and I'll probably make all parties mad, and that's okay. When you come, there's 4 people to speak. For those who are against the amendment, I don't want to hear how great the workers' comp or the advisory council has been. To the other side, I don't want to hear how bad the council has been. I only want to hear comments directly related to the bill. Okay? No commentary about history or where we've been okay? So, with that, John Poole. And I am asked if again, because we've gone through this pretty thoroughly, try to limit to about 2 minutes. Thank you.
Thank you, Mr. Chairman. Members of the committee. You did trim my presentation down quite a bit. I'm here to represent 2 associations, Georgia Paper and Forest Products Association, and also the Georgia Workers' Compensation Association. GWCA, just so you know who we are, includes some of Georgia's largest employers, most of whom are self-insured, and most of whom operate in multiple states. So they bring a fair amount of expertise. I think they're troubled with this bill primarily for some of the reasons that have already been mentioned. Some of the language is relatively vague and subjective, and our concern largely would be that we will see a great many lawsuits come out of a bill like this, and we would urge that it be looked at and tightened down a great deal. We understand that oversight is a prerogative and a duty of the legislature, and we certainly concede that. But we think this bill is far too regulatory in nature and far too vague. And we would ask you to take a long, hard look at it. Thank you, Mr. Chairman.
Aubrey Valines.
Thank you, Mr. Chairman. Aubrey Valines with the Georgia Injured Workers Advocates. We support this legislation. I want to talk about the legislation, and I've greatly reduced my talk as well. This is simply legislative oversight. It's trying to prohibit another body, an administrative body, from legislating when the legislature should legislate. If you look at this bill, it's neutral on its face, and it's neutral all through. It doesn't favor employers. It doesn't favor employees. It's simply about allowing you to do the job, one of the many jobs you're supposed to do, and that is legislative oversight, where rules would come to you that would normally be introduced as law to make sure that agencies aren't making laws with a rule. It's very, very simple. Representative Park brought up a good point. Most of this language, or much of this language, comes from the Administrative Procedures Act, which has been around since before I've been up here, and I've been up here a long time. And in some of it, a few years ago, you may or may not remember, there was a bill entitled House Bill 952 that was introduced by Chad Nimmer on behalf of the governor. And that bill put all the professional licensing boards, the dentists, the pharmacists, the nurses, the doctors, under rule review, where any rule that any of those boards proposed ultimately had to go back and be reviewed by the governor's office. Now, they are also reviewed under the Administrative Procedures Act by the legislature as well. So this is not overkill. This is standard. This is very standard, and I'm not on the advisory council. I have been on the advisory council in the past, but I'm not on now. And I realize that it works on consensus, that they come to an agreement, and then they come to the legislature, and everyone who is on that body, on the advisory council, basically agrees they're not going to come down and oppose anything once they've reached a consensus. But I would tell you one thing about that, and very, very briefly. On the legislative committee, there are 8 employer representatives, 5 employee representatives, and 3 government representatives. That's an 11-5 consensus. if it were reversed to the favor of my employees, the consensus would be very different. And I don't complain about it because life's not fair. But I just want you to understand that sometimes consensus matters as to who has the majority and who doesn't. This is excellent legislation. There's been some talk that maybe the advisory committee could go back and do something similar to this and take this and change it. The advisory committee has had 20 years to do something like this, and they haven't done it. Legislative oversight is a good thing. And again, when you look at this bill, the thing you're going to notice, it does not favor any side over the other. Thank you very much, and I'll be happy to answer any questions anyone might have.
Thank you. Bill Clark.
Thank you, Mr. Chairman. I am Bill Clark on behalf of the Georgia Trial Lawyers Association and our 400 lawyers who do workers' compensation around this state. In sharp contrast to the previous speaker, we are opposed to this legislation, not on its merits, because in all candor, we have not had the opportunity to, we've read the bill, but we've not had the opportunity to assess what real impact it would have on the board's ability to do what has gone well, what has been done well, which is to bring all of the stakeholders and all of the experts in this area together to work through issues important to all sides, but more importantly, to work on issues important to the workers' compensation system as a whole. And I think the last thing that I would add is that advisory council, I'm not going to talk about how great it has been, but I'm telling you that as legislators, you want a group of expert stakeholders advising you before you are required to push the green and red button on legislation. And if you get rid of that process, if you interfere with that process so that they can't provide you the best information, then I think you're doing, you would be doing a disservice to yourselves as legislators. You guys have got thousands of issues to deal with on a daily basis. You need to be able, and I'm telling you what you already know, you need to be able to rely on people who know this area of the law and to be able to cast your vote based on what that expert group brings to you. And I would submit to you that the advisory council process will continue doing that well in the future. And if it doesn't, then there's an opportunity perhaps to step in. But at this time, we believe that the advisory council serves you, and more importantly, with all due respect, your constituents all over the state. And we would ask you to hold this bill rather than pass it. I'm glad to answer any questions that there may be. Mr. Chairman, thank you.
Who's 28? Chairman Fleming.
Thank you, Mr. Chairman. Mr. Clark, I came in the middle of this bill. I apologize. Tell me what you think it does.
I'll be very candid with you, and you've never heard me say this. I don't know, Mr. Chairman, and that's the most honest and accurate answer I can give you. And my members don't know. They want to look at this. They want to look at it and assess it, and that's what we do with every proposal that ever comes up that affects the workers' compensation system. We get together, the business folks get together with their people, and then we come together, business and representatives of injured workers, and come up with the best solution to recommend to you that benefits the comp system and the people of Georgia. But not having the opportunity for my members, my part of the expertise, to assess this bill, I don't know the answer, is the honest answer, Mr. Chairman.
Okay, thank you.
Representative Gilligan.
Thank you, Mr. Chairman, and thank you, Mr. Clark. My question would be, do you have any kind of idea how much time it would take before your organization would have the ability to adequately assess the language in this bill?
That's a fair question, and not to repeat myself too often saying this, I don't know. And the chairman's asked us to not talk about how great the advisory council process is. Let me just say that in the absence of the opportunity to bring all the stakeholders together outside of the rush and mayhem that is a legislative session, absent that ability, mistakes can be made. Problems can happen in legislation. Legislators can be blamed for casting a vote in an area of the law that they don't know anything about because those with expertise did not have adequate time to assess the measure and then bring you a recommendation. So that's the best and I hope most honest way I can answer your question. Absent adequate time, problems will happen. I think, as we do every year, when issues come up, frequently whoever's chaired this committee and then the similar committee over in the other chamber have had issues, and they've said, advisory council, y'all go take a look at this. And if we don't, then I think it's perfectly fair for the legislature to come in and say, you had the opportunity, we charged you with the responsibility of looking at this issue, you didn't do it, now we're going to act. And I would submit to you, if we don't do what we should, then you should do that. But we're not there yet, with all due respect.
Okay, thank you.
Thank you, Mr. Chairman, members of the committee.
Roy Bowman.
Thank you, Mr. Chairman, members of the committee. My name is Roy Bowen. I'm the president of the Georgia Association of Manufacturers, and I have the honor of serving as chairman of the advisory council to the State Board of Workers' Compensation. I will tell you that in our view, my view, the view of our association, House Bill 474 really seems to be a solution in search of a problem. The advisory committee process is embraced by all of the engaged stakeholders. I think you've heard some representation of that today. The advisory committee has always been open to, and in fact has encouraged legislators having questions or constituent concerns about the system to bring them to the advisory council so that it could assist in addressing those questions or concerns. The advisory council does not make or change law. If Representative Kirby or any other member of this committee or any member of the General Assembly has an issue with specific board rules, the workers' comp statute, or the advisory committee process, we want to hear about them. And we want to work to address them by calling upon the expertise of the engaged system stakeholders. And to my knowledge, this system has worked well. Now, that's not to say some mechanics or process can't be improved upon, and that's an ongoing process with the council. I do not view House Bill 474 as an improvement to the process or the system. Quite the contrary, I predict that this bill, should it pass as drafted, would lead to a return of the system and the process that caused great angst for the General Assembly by way of introduction of countless bills each session, contentious bills, the erosion of confidence in the system by the stakeholder groups, and would negatively impact Georgia's economic development efforts. As chairman of the Advisory Council, I want to assure this committee, and especially Representative Kirby, that the concerns that have been raised will be a focus of intention by the Advisory Council during the coming months. And with that commitment, I'd respectfully urge that you not act upon the bill. Thank you.
All right, thank you. I'm sorry, Chairman, hold on, Mr. Bowen. Chairman Fleming.
Thank you, Mr. Bowen, for being here.
Yes, sir.
Same question I gave to Mr. Clark. What do you think this bill does?
Well, I think that it has the potential of politicizing a system that's not politicized right now. I think it has the potential of delaying and making progress in the area of assisting injured workers by rulemaking. I think it has all kind of negative potential. I don't think that it represents an improvement whatsoever in the process that we have in place today.
I guess as I attempt to read through the bill now, I'm looking at line 78. In the event a standing committee to which a notice is assigned as provided in subsection D of this code section files an objection to a proposed rule prior to its adoption, the proposed rule shall not be adopted. I once again apologize for coming in late because I had another committee I had to serve on, but it appears to me that that gives this committee the ability to put a pause on rules adopted.
I think it gives the opportunity to give a veto power to rules that have been adopted, and really without the provision of any hearing or anything of the sort before the committee.
Well,
and again, that I would submit to you that the rules that come to this committee And they come, I mean, there is record of the rules being transmitted to the committee. Now, we may want to look at ways to improve upon that mechanism to ensure that there's proper receipt. But those rules are crafted by the stakeholders of the system. The employers, representatives of the injured workers, insurers, medical providers, all the system stakeholders. I will tell you that Rules Committee meets monthly and painstakingly goes over these rules. They're not making laws through the rulemaking procedure. And when they do come, when the rules are promulgated, they do represent a consensus. And I would take exception to Mr. Valines. There's a good balance on that advisory council of folks that represent every stakeholder group.
That's what's got me confused, you and Mr. Clark on the same side.
Well, it's like,
Dewey and I both signed it, that ought to confuse everyone.
yeah. Yeah.
Thank you.
Chairman Pruitt.
Thank you, Mr. Chairman. Just a quick comment, not a question. I had the opportunity to serve on that council for a little while. And serving on that council, I can tell you that there is gut-wrenching, conscious decisions that come from the heart. And the decisions are not made easily because people do differ, as you bring to our attention, Representative Fleming. And I've seen a lot of battles back and forth in these committee meetings, and so it's not taken lightly. A lot of time is put into it, a lot of effort. I enjoyed the time I spent there, short time, but I can only give you my experience, and my experience is it is a very well designed, and at the time I was on there, the committee members were very sincere about what they recommended, and they didn't make quick decisions. Just my comment. Thank you, Mr. Chairman.
All right, Bobby Potter.
Thank you, Mr. Chairman, members of the committee. I'm Bobby Potter, and usually in these circles I represent State Farm Insurance Company. State Farm does write some workers' compensation, but precious little of it, frankly. But I've spent 41 years in law practice in this world of workers' compensation on the defense side, but at least the last 25 of that participating in this advisory committee process when Chairman Dawkins asked me to be a part of it. Back then, I've been involved in it ever since. For the last decade or so, I've lost track. I've chaired the legislative committee. And the folks on the rules committee would look at me and say, thank God you're doing that. I don't want any piece of that. And I'll look at them and say, thank God for you all doing what you do, because I don't want to do that. They meet once a month to look at and craft rules. And so I want to tell you that from the standpoint of the background. And Chairman Fleming, I had this in my notes from earlier this morning, but I would say the subjective answer to your question from my perspective is it's very, very difficult to take politics out of politics. You all have heard that many times. That's particularly true when y'all get to the point of redrawing lines about who runs from where. That may be the most gut-wrenching part of politics. The advisory committee, as Chairman Pruitt had just indicated, does the best job they can to take politics out of it and deal with issues and bring their expertise to that away from this setting, and to do so in a thoughtful way. The Rules Committee does that as well as anybody I've seen, because they meet periodically, they know each other, they live in this world, and they get into the weeds of what would make sense, and they don't do it in a rush. I would say that from their perspective. Earlier this morning, I think in the room just above this, Chairman Knight was presenting a bill to the Insurance Committee dealing with PBMs and pharmacies and consumer protection, several other groups at the same time. He said, everybody is in agreement with this, and frankly, that's the way it should work here more often. Well, that's why the advisory committee brings value to you all and to the State Board of Workers' Compensation, because they can do that. What's really important in the bill that's across the way and will be coming over here is not necessarily what's in it, but some of the things that are not in it, because they haven't been fully baked enough because of that consensus process. Mr. Valines mentioned the numbers, and I too would say that's kind of a false narrative in regard to who is who. Having chaired this legislative piece of that for more than a decade, not one time in that time have I asked for a vote, not even a straw vote, as to who is who. It is, in fact, consensus-based. There's a very thorny issue going on now nationally and in Georgia, and it touches this workers' compensation world, dealing with medication and opioids and prescriptions. That's what I reference. It's not fully baked yet. If it had come to a vote earlier, it might have gone in a different direction. That's not where it is. So we're working on that from that perspective. Relative to Representative Kirby, I want to talk to him earlier about this issue. I've lost track of time whether it was yesterday or today. I think it was yesterday, Representative Kirby. He referenced on the road Rule 240. He referenced that again today. 240 and 240A has been part of the rulemaking process for quite a long time ago. This is nothing current. And while he may believe from his perspective that works in that setting adversely to employers, there are folks on the other side that would say some of that works adversely to employees. Certainly in that 240 setting, it goes both ways, and there was lots of discussion getting to that point where there's a balance. I would suggest one other item to you all that you did not reference. In the medical world and picking doctors within a panel of physicians, in this last decade, there have been mergers of lots of folks, mergers of hospitals, mergers of orthopedic groups, and there's a rule that deals with picking doctors disassociated with other doctors. As these mergers occurred, that became more and more complicated. The rules, the board looked to the rules committee to come up with a solution to that will be quick to expedite and put in place, and they did precisely that. If you weigh that process down with a tad more politics and shift that to the legislature overseeing that on a regular and current basis, I think you would do a disservice to this system, to the State Board of Workers' Compensation, and frankly, to yourselves. There are a lot of folks engaged in this process, some of whom have spoken here today, a bunch of alphabet groups, and most all reach consensus through that process. So I would likewise ask that you would be best served by holding this bill. I'll be happy to answer any questions.
Thank you. Chairman Fleming.
Thank you, Ms. Potter. I appreciate that. I would just ask you the same question. What is it that you believe this bill does?
Well, technically, I think this bill requires some specific notice. It allows people to sign up to receive that notice and get notice of whatever proposed rules are coming. It is very specific about what it would obligate the board to do in terms of what the proposed rule is. This is a synopsis of that rule, what the rule was, why you're doing it. And from that perspective, the one item that just is interesting to me that kind of jumps out is, and actually Representative Park referenced that on line 58, which is a tad amorphous, looking at alternatives about excessive regulatory costs. And this is providing some built-in effort and cost just to comply with this. I think it does that, Chairman Fleming. There will be there will be opportunity for a hearing and more input, and I don't know relative to subsection 2 at line 54 through 56 how that would be portrayed when you get back to your reference to the line 78 and 80 as to whether or not this has been complied with and whether or not a standing committee could simply object to it. The one line that did stick out to me, and I think Representative Park referenced that as well, is the term adopted in exact compliance. Maybe that's in the APA, but that is a lawsuit waiting to happen as to whether or not there's exact compliance with all these things on A and D, and particularly the somewhat amorphous things in A.
Thank you.
All right, Representative Clark.
Thank you, Mr. Chairman. Thank you for your testimony and presentation.
Yes, sir.
A question I had was, does the advisory council, when they do promulgate their rules, do they provide notice?
So the answer to this is the advisory committee itself is just that. It is an advisory committee to the State Board of Workers' Compensation. So they don't promulgate rules. The State Board of Workers' Compensation is the state agency and the entity that does the promulgating.
Thank you. So then does the board provide 30-day notice at the very least?
I don't know. I'm kind of like Mr. Clark from that perspective. I don't know the answer to that. They have to publish these, and it comes in this book that lawyers all get and follow.
They do by rule have to provide it.
Okay, thank you. Mr. Blinds tells me they do by rule have to provide, what, 30 days notice?
Not 30 days, but notice of the rule.
Okay, so that's what I'm told is the answer.
Yes, sir.
So, but I don't live in that piece of that world.
I have it right here.
I think what I was trying to get to was whether or not the board essentially already does A1, lines 40 to 53. Because I think there does seem to be, given some of the concerns that I've heard, need for some oversight, and at the very least, 30-day notice with some of these requirements seems reasonable. I'm not comfortable with some of these provisions that I pointed out earlier, but going forward, I think I'd be curious to know kind of what currently exists and what may be needed legislatively.
So, if I may respond to that, what I would suggest is this. And you've heard about this advisory committee, that it does in fact advise the chairman of the state board, and oftentimes when there's legislation referred, they take a look at that on behalf of this group and respond to that. I would point out this, that I heard it on the other side. All rules have to go through the advisory committee, and all legislation has to go through the advisory committee. That is just certainly not accurate. It can be helpful, and we can vet things and provide that information. And likewise with this piece of legislation, I would suggest to you all that you hold it, that you send it to this group of people, including the State Board of Workers' Compensation, to look at this interaction between you and this state agency, who needs notice and when, and whether or not, and how many public hearings there might be held in the off season. Generally, these rules go into effect July 1. Most laws go into effect July 1. The board works on this, presents them, and they'll go into effect July 1. This thing gets published and distributed to everybody, and of course these days it's online as well.
Thank you.
Okay, thank you. Does anybody who did not sign up want to speak? Okay. Justice, come on up.
Hey, thank you, Mr. Chairman. My name is Terry Chastain, and I am on the State Board of Workers' Compensation. And I just want to say that the Advisory Council does do a great process, and oversight is not a bad thing either. Specifically with this bill, the last part of it, I think probably could be massaged better. I'm concerned about the language specifically saying that the committee gives notice of objection to a rule. Right now, under the APA, it's 2/3 of both committees of jurisdiction would get together and vote, and any agency would have an opportunity to come and present to that committee in a formal process. So I don't know if that means chairman of the committee or the full committee sends a letter. I think we could work it out. I'm not saying it's insurmountable, but I just wanted to point something out specifically there that I was trying to work through. If anybody has any questions, be happy to answer them. Or
Okay. Chairman Fleming.
Thank you, Judge, for being here today.
Thank you, Mr. Chairman.
You're talking about your reading of this bill. Do you have any experience doing that?
Very little. Normally, I relied on members of the General Assembly to tell me what they thought the legislation did, but
Thank you.
you're welcome.
Okay, anybody else want to speak? Seeing none, I'm not going to entertain a motion to move on this bill. What I am going to do is send this legislation to the advisory council so that it will give y'all, we are at the beginning of a 2-year biennial, and ask that y'all bring this back to us in acceptable form. Because we've had so many more members come in, Representative Kirby, while you're there, we are going to revisit House Bill 110 and give us for all the new members, the change you made. But I haven't recognized you right now.
Need a motion.
I think so.
Yeah.
Okay.
At the appropriate time, sir, I'd like to make a motion to reconsider our vote on House Bill 110.
Is there a second? Okay, all those in favor?
Aye.
All those opposed? Well, we're about to, but we're going to let. The motion is passed. We're going to do that at the proper time. Kirby.
Thank you, Mr. Chairman and members of the committee.
And I will recognize you at the appropriate time.
Another bill we hadn't did anything. You said you would not make a motion to do anything on 474.
I sent it to advisory council.
So did someone made that motion from us, from this committee? Or you just did it as
We don't
chairman?
have to. I can do that as chairman. We do that all the time before it ever gets here.
Okay.
You can check Ledge Council on that if you'd like. Okay, what's yours?
Someone made a motion, someone second. Robert rules require that we discuss, and mine is only on the motion someone
Okay.
made a motion to reconsider.
Make a comment.
And so basically, I was one of the ones that came in late, so she made a motion to reconsider, and I'm not sure if I heard what we were reconsidering, so I was trying to understand what were we doing. I know you guys kind of do what you want to, but I just haven't seen this one.
Okay.
So can y'all just help me through this?
May I clarify my motion?
Go ahead.
Okay. I would like to move that we can reconsider our vote on House Bill 110 to be considered once we have valid and new information from Representative Kirby to address the issues and the questions that we had regarding this bill at a later date.
No. You can do it now.
I don't have a second. Okay.
Or now.
Okay. I'm not at a later date, sir. No. Now?
I'm really confused what we're
We
doing
want to
here.
hear it.
Well, I'm gonna leave it because this is really just got to be off.
Pardon?
This has got to be something I ain't heard before.
Well, sir,
Mr. Chairman, if I may.
Go ahead.
I think the lady's point of order is to whether or not she had an opportunity for discussion during the motion to reconsider. Is not your point of order?
Yeah, but I think she just changed her motion, so now I'm
yeah,
really
now I'm
confused.
confused.
The motion is already passed.
Well,
But
you can't, how are you passing a motion without us having any discussion on what it was we were voting on? So that we could all be clear why we were voting.
I wasn't addressing that point. You said that she was withdrawing her motion. It's too late. It's already passed. But I will address, if you'll allow me, your question.
Well, no, I think my question was to the chairman, and then the gentle lady went and made a different motion, so.
And the chairman recognized me, and I'll respond to that if you will allow me.
I think you're gonna do what you want to.
No, I'm going to do what the chairman recognizes me, and I'm going to respond to your question. I'm not sure that a motion to reconsider is debatable. However, if the chairman wants to allow a debate on that, he certainly can. Now, your objection is that you were not allowed to find out, I think if I heard you correctly, what we were doing. A motion to reconsider can be brought during any meeting that is still ongoing about any action this committee took previously. The lady's motion for reconsider was in order, and it did pass. Now, your question was, could you debate that? I'm not sure you can, but I think now your question is you just weren't sure what we were doing. But the motion to reconsider was had, it was passed, and this bill is now before this committee again.
McLean, do you want to make a comment before he?
If I can, Mr. Chairman,
Okay.
because, it's what my point of order was in reference to 474, is you were sending it back, which I had no problems of, but we were at HB 110. We already said we were not going to move on it, but now we're back to it. So I'm not understanding how we can not move on it and then we move on it.
Because we had a tied vote. We had 30% more members come in here, and Ms. Gilligan made a motion to reconsider, which, if you'd like to see the rule book, it passed, and I'm asking Representative Kirby, since more members came in,
So
go over the
Mr.
changes.
Chairman, so us that have already heard of all of this, we got to rehash this again.
Sure.
I'm just trying to figure out where we're going with this.
I will be as brief as I can, Representative McLean. And do I have the floor now, Mr. Chairman?
Yes.
All right, House Bill 110, we've discussed several times before. Very quickly, what we did on this LC 36387OS was on line 33, adding the words about giving options for employees to choose. Every company to have, of the 4 ways we can pay them, they'd give option at least 2 of those. We talked a little bit about why we couldn't add the covering of the cost, because of so many different things the cards on a money card may do. And that's really all it does, is just it gives the employees option of how they want to be paid, that the company's going to give them at least 2 of the 4. Company could give them all 4. But it's really pretty simple and straightforward from there.
Are there any questions? Mr. McLean?
Yeah, thank you, Mr. Chairman. Again, as I said earlier, the concerns I have is that why were the lines strucken on 45 through 53 on the back? That was one of my concerns. And you stated, because I just wanted to make sure they could opt out. I mean, if I didn't want anyone to, I didn't want you to understand, because if it was there, I just thought it could stay there. Not that if a person wanted to get out of there taking their card, they could do it.
Like I said before, I don't think they have to opt out. They just ask.
So can we put that back in?
I don't think its wording's needed. I think we're just being superfluous, and we're adding extra steps that employees would have. I mean, this actually says an employee would have to do something formally, and they don't need to do that. Just go to the HR and say, hey, I want change. That's easier. We don't need any of that.
Okay. And I think the only other thing that I stated on your question was that, as I told you, I talked to a lot of the young college students, and they were concerned about them, getting money on a card and them being followed, and the fees and the transactions and the amount of money and things that they would not be receiving because of that. But I guess, for the sake of the committee that was not here that heard all of that, I guess I'll try to make it brief too, that you can tell them what the fees are and everything else.
Yeah, there'd be no fees for just actual use of the card. Unless they're, some of the things we talked about, international on the one that we have a copy of here. Like I said, tracking people around, these chips don't really do that, any more than any other banking transaction does today. So whether they're paid by check, cash, direct deposit, debit, money card, doesn't, people are selling information all the time. I wish they didn't, but I get those emails because they sell my information too. So.
Thank you, Mr. Chairman.
Mr. Kennard.
Thank you, Mr. Chairman. Representative Kirby, still have the question about it would be required for every business corporation to offer the two forms, and I think that makes sense for larger companies. In the interim, I have polled some of my small business constituents, and they would very much be against this because of very small payrolls. Offering more than one form of payment could be a burden to them.
Well, right now they have 4.
Is required,
But if you would
4
like,
is required?
yes, that's what we're addressing.
Okay.
If you would like to change it to what your constituents like, we can take the 2 options out and just let the company say, here's how we pay people.
Is this, could it be classified along size of business lines? Small businesses would be exempt from this?
So why couldn't the big boys choose how they want to pay them if the little guys can? I would do one, I mean, I agree with you. If you want to take out the options and just say, the business will decide how they're going to pay people, whether it's a small business or a large corporation, that is the easiest thing to do, and I think in my world, actually makes the most sense, but in some of the discussions, we're trying to work with some questions and giving at least an option, but you're correct. For a small business, if they want to just do one way and that's the only way they do it, we could take that option out, and if that's the form of a friendly amendment, I would certainly entertain it.
Chairman Pruitt.
Thank you, Mr. Chairman. When you came before us before, I asked a question about the availability. If a company decided to use these cards, the availability across the state of Georgia and all the banks, and at that time, you mentioned that there was a fee if you went to a bank where you didn't have a checking account, that there would be a fee for being able to turn that card into cash.
No, a lot of banks charge a fee to cash a check if you don't have an account there. Matter of fact, it says clearly on this one, and I could go online and look at, this is the Money Network. Any bank, and it says in here, any bank that is part of the network, and there are all so many networks out there, as we know today.
Well,
they don't charge any fees to take any cash off this. Also, with all the cash back we get at stores and things, there's no cost to that either. So,
can I have a follow-up question, please? I just want you to understand where I'm coming from. And in the community where I live, we have only community banks. We don't have any major banks. They're privately owned, small people, in small groups. I don't know if they're a member of these networks or not.
And these cards are also available at Walmart. Walmart has their own money card. That's one of the things I did check on, because Walmart's all over the state of Georgia and makes it very easy for everybody to access it.
Are you suggesting then if a company lives in my area and
these are mailed in for free and given to employees for free, but if they don't want to do that, but they need, and of course they can still pay by check, they can pay by cash, they can pay by direct deposit, however they want to do it. But if they want to use one of these cards, which is already in the law, I mean, Walmart offers those. But they did find out they charge $1 for a card.
One last clarification, then. A company can, if they do checks now, they can continue to do checks.
Absolutely.
An employer cannot come up and say, look, this is what I want to use right here, and this is how I want you to do it.
And as Representative Kennard said, I mean, if they feel it's burdensome to give 2 options, and a small employer just wants to do one, I would certainly ascertain a friendly motion to remove the 2 options and just go with, it's up to the company to say, here's how we're going to pay our people.
The non-amendment is something that I would certainly support.
Well, if you want to make the motion, it's up to the committee.
I have to get some wording down, but okay.
It would just be withdrawn. It would just be to remove Section C.
Well, let's finish the discussion, then we'll.
Okay. Representative Carter.
Thank you, Chairman. And thank you for those questions that were just brought up. So I have a couple of questions, and I think the thing that, as we look at this bill, the new language that's being added, or the new law that as I've polled, not just my constituents, but just polled workers throughout Georgia, on line 17, language is added upon the discretion of such person, firm, or corporation. if that wasn't in there, we wouldn't necessarily be changing the law. What you're saying, what you said earlier to Representative Kennard, is that we would be changing from 4 options to 2. But when you add that it's upon the discretion of the person, the firm, or the corporation, so if employee that prefers to have a check and not this card, it's up to the employer's discretion to decide that. And help me understand if that is not true.
Under current law, are you talking about current law, or what would change it to?
No, on line 17 in the amended substitute bill HB 110 LC 36387OS. Line 17, you're adding language that says,
correct,
upon the discretion of such person, firm, corporation. So prior to this being added, if it passes, it wasn't necessarily upon the discretion of the employer. And so I'm saying, I understand you said that there's 4, and now this one has 2, but I think we have to deal with this, because if you have an employee that is insisting on a check, it's upon the employer.
As I read the current law, the intent was always to be on the employer's discretion. However, over time, some different rulings have said, well, you got to make these exceptions, and then they put in the formal opting out language. That's why we don't need to opt out. What this does change it now to give them 2 options, but as Representative Kennard says, he feels that may be limiting small employers, and that's where, upon the discretion of the company, here's how we're going to pay people.
So, okay, we danced around this the other week, because it's still not clear to me. Dealing with whether the options is on another section of the bill. I'm only dealing with 17. So are you saying to me that adding this language is saying that we're giving the employer to offer 4 options, or we're giving the employer discretion to 2 options?
When you add the wording on 17 along with the paragraph C, it adds at least 2 options. Can be all 4, but at least 2.
Right, but I want to do apples and apples. When you add this line, upon the discretion of such person, firm, or corporation, the employer is at the employer's discretion.
Yes.
What the final decision is, whether it's a check or not.
But you got to add in
Stay
C.
with me right here. If you just help me right here.
They got to go together. You can't do one without the other. Right now, the way it's written, it'd be the employer's discretion to they have to offer at least 2 choices. And the employee could choose.
Upon the employer's discretion. So if
the employer decides what 2 choices they're offering.
That is my point.
The employee
Okay.
chooses, but like Representative Kennard said, if that's a burden on the small business, we'll pull the 2 options out.
Well, my concern right now is not so much the burden on the employer, is the employee, because the chairman earlier to ask you the question and talked about he's in a community where you only have these community banks. And so what it's starting to sound like to me is this is not really about having choices of how to be paid. It sounds like it's a payroll card bill, because your option to him is, well, if these local banks do not offer this card, then they can go to Walmart. So this bill is starting to sound like it's more about the card than how people get paid.
It's not just more questions about the card because more people are unfamiliar with it, I think. But
I'm gonna have to disagree with you with that one, and I'm still not sure that you've answered my question, but I'll relinquish the mic.
Okay. Everyone's lit up right here, and we've got the room to 4 o'clock. And although I think, Mr. McLean, you thought I was trying to revote because we had more members come in for that purpose, this is why I wanted to revisit it. We had a lot more members come in, and I think there's still more questions than answers. So I'm not going to accept any motions to move this bill, and we'll revisit it, table it, but at this point, this is a hearing only. And at this point, we are adjourned.
Thank you.
Yeah.